My name is Jim Moliterno. I'm at Washington Lee Law School. I've been here for 3 years after a number of years elsewhere. I teach professional responsibility, and I have a leadership role in our new third-year curriculum. The immersions, fall and spring, are sort of opening acts for the rest of the semester. And so in the first 2 weeks in the fall, the students are ours in the immersion period. They work with us from 9 to 5 in those 10 school days and the weekend that is in between. The rest of their third-year curriculum courses have not started yet, so they're not yet in the practicums. They are intensely consumed by the immersion experience that they have both fall and spring. And so those are meant to get them certain skills and some knowledge in a very focused, intense way. The fall immersion is the one that's oriented toward litigation. In that immersion, the students begin it by interviewing somebody who's playing the role of their client. They walk through this piece of litigation from start to finish, essentially, doing some document drafting, complaint and answer drafting. They do some negotiating, they do some discovery, they do some motion practice. They then prepare for a sort of truncated trial, and on the last day of the first immersion, the fall one, they conduct a short trial of the very case that they've been working on for the 2 weeks. All along the way, we follow what has become the tried and true method of teaching in an experiential mode. We deliver the theory of that activity to the students. What makes a good client interview? Sometimes that theory is delivered by lectures, sometimes it's delivered by reading assignments, sometimes it's delivered by demonstrating what a good client interview or the particular activity would look like and be like. The students then get a chance to drill, essentially, at that skill and get critique from their supervisors and their peers about that activity. Then they get a second opportunity to engage that particular activity for the case that they're going to work on for the 2-week period. So all the way through that 2 weeks, we'll have sessions in which we deliver the theory, sessions in which in small groups the students do drill activities, and then the opportunity for the student to do that activity in their simulation that's going to run through the course. Essentially the same thing happens in the spring semester, but it's transaction oriented. After a first day in which we provide a sort of transition for them between the sort of work lawyers do in litigation and that they've worked on in the fall immersion and the sort of work that lawyers do in transactions, planning, forward-looking work that they're going to do by and large in the spring immersion. We have 1 day of transition to get them from one mode of thinking and acting to another. They then are cast in the role of a lawyer who's representing either the buyer or the seller of a sort of medium-sized business. And they begin actually by watching a short video clip of the possible buyer and seller meeting each other at a trade show, where they begin to have a conversation about whether one might buy the business of the other. And then they set out to meet their clients and to negotiate and draft their way through a wide variety of issues that come up, legal issues that come up in the context of that transaction, until at the end of it, they are drafting as much as we can get them to draft in a short 2-week period. They are drafting the actual document that affects the sale of the business. We require both the litigation immersion and the transaction immersion of all students for a few different reasons. One reason is that we think students, even the students who are sure they know what they want to do in life, find that they're less sure after they have more and more experiences in the role of lawyer. And so we've actually had a number of students who have come to one or another of us in the program to say, I thought I was going to be a litigator, and now I know I don't want to do that. And so in an interesting way, we've had students who essentially have made their first career change before they even leave the law school, which I think is a tremendous advantage. Most of our graduates these days are going to go through a couple of different careers, if you will, in the law over the lifetime, and to have them have a bit more certainty when they leave and even make a first change before they leave, I think is a big advantage. So we want to expose them to both because we're dubious about whether they're right all the time, even the students who are sure they know they want to do one thing or another. The other reason that we want them to do both is that for a litigator, it's a good set of knowledge to have to know how a transaction works. Litigators often are litigating over failed transactions. And so for litigators to have some understanding, at least some exposure to how transactions get done and how they work and how lawyers think when they're making the transaction, try to make the transaction work, we think that's an advantage, and vice versa as well. For transactional lawyers, they should know what the consequences are and how litigation feels for their clients, what the possible consequences are as they're trying to make a transaction work. So we think that a well-rounded lawyer ought to know about different modes of lawyering than the one that they happen to be engaged in even as a career.